Eric Sitter appears with Steve Davis, who appears in person in custody. Mr. Davis is eligible for public defender representation, would acknowledge receipt of the criminal complaint. Judge at this time would move to strike the domestic abuse repeater that's listed in there. Just as a quick basis, I know the state lists that there is a conviction for strangulation suffocation, which did have a domestic abuse modifier in that Dane County case 18 CF 1878. They also list contact after domestic abuse. Looking at the statute and looking at that case was not charged out as a domestic abuse offense. There was no modifier that was included in the conviction, nor that I can tell that was waived as part of that. I think that's the other count that they rest on for the 2 or more previous convictions. So based on that, would move to dismiss the repeater.
Did he say his address was correct? Or was it changed?
We would update the address, I believe, to 200 Park Circle, Sun Prairie, Wisconsin, 53590.
The allegation itself says domestic abuse repeater having been convicted of 2 or more occasions of a felony or a misdemeanor. 2 or more separate occasions. Response to position of defense.
I'm taking a look at the case ending in 1878, and I'm not sure if I'm reading something incorrectly, but I believe it did result in a guilty plea to count 1, the strangulation and suffocation, with the domestic abuse assessments. Don't have anything more to add in regards to that.
It says having been convicted on 2 or more separate occasions of a felony or a misdemeanor, as alleged. I see the strangulation and suffocation. And the contact after domestic abuse arrest. His allegation, if I get the argument right, is because there's not a domestic abuse enhancer. It's contact after a domestic abuse arrest. Therefore, it's not a domestic related. Counselor?
Judge, I think the language in the statute that makes the repeater talks about 2 or more separate occasion convictions of a felony or a misdemeanor. And then it goes on to state for which a court imposed a domestic abuse surcharge. And that applies to both the convictions. And so these convictions, the one had the domestic abuse surcharge, the second conviction, that misdemeanor conviction, did not. And I don't have any indication that that was waived, which is the other, I think, avenue that the statute contemplates. So I think as charged, that misdemeanor conviction they're relying on doesn't satisfy the domestic surcharge requirement in the repeater statute.
Counsel?
I have nothing more to add, Your Honor.
I'm looking at the assessment report in 18 CF 1878. And so when I look at the domestic abuse surcharge, it is applied in count 1. I'm assuming that's what DOMAB, and then $100 balance due to the clerk. Count 7 has no such surcharge. It has a CLD, which is similar to count 1. Count 7 has a VW, which I'm guessing is a victim witness surcharge. Count 7, I see no domestic abuse surcharge. The charge itself is clearly contact after domestic abuse arrest. In light of the language as stated in the charging paragraph on the repeater, it says, further invoking and sub 2, because the defendant is a domestic abuse repeater having been convicted of 2 or more separate occasions of a felony or a misdemeanor, and it lists the felony and the contact after domestic abuse in which the court imposed a domestic abuse surcharge, or for which a court waived the domestic abuse surcharge, or was committed in another state, that doesn't apply, or that is a crime of domestic abuse under the laws of that state. It's on here. There was no domestic abuse surcharge applied to the contact after a domestic abuse arrest. Any argument on how that repeater should not be dismissed at this point? Nothing?
I don't have anything more to add.
For today's purposes, I believe council's correct. There is no surcharge that's applied. Clearly, it's a domestic charge itself, but the court made no waiver. The court applied no surcharge. Therefore, it doesn't apply as a repeater basis. So the repeater portion is dismissed. Just looking at the original judgment back from 18 CF 1878. I don't see any application as set forth in the criminal complaint. There may be other convictions, but that's not what was relied upon by the state. I don't see any exceptions or waiver by the court from the judgment in 18 CF 1878. Therefore, I don't believe there is a sufficient basis alleged to allow that repeater to continue at this point, and it is dismissed. Anything else on the charges or complaint, counsel?
No.
I have reviewed the criminal complaint. I do believe there is a sufficient basis to find probable cause. I will enter a not guilty plea on Mr. Davis's behalf to the remaining charge and enhancer. Counsel's position on bail.
State's recommending a signature bond along with the conditions that the defendant have no contact with Ashley B. and a ban from Park Circle.
Counsel.
I can go to somewhere else. That's my brother's address, but yeah, I'm okay with that.
No objection.
I will then order a signature bond for Mr. Davis. I will order a no contact order with Ashley B. You can't call, write, text, message, no contact whatsoever while this case is pending.
Yes,
And that you are banned from the Park Circle address.
yes, ma'am. Is it the way that I can get in contact with you guys, but I don't know, my stepfather's exact address. Address right now. Just call them up. Okay, all right.
Update the court with your best mailing address. You're gonna get a court date today, but you need to make sure you get notice in the future, so you'll need a different address for that, okay?
Yes, ma'am.
We are adjourned in Mr. Davis's case.
All right, so.
Next be Dustin BELK.
Dustin Belk. Stand with no X.
Court will call 25 CT 849, State of Wisconsin versus Dustin BELK for initial appearances.
Sam Smith for the state.
Eric Schlitter appears with Dustin Belk, who appears in person in custody. Mr. Belk is eligible for public defender representation. The address listed on the criminal complaint is correct.
I have reviewed the criminal complaint. I do make a probable cause finding. I will enter a not guilty plea on Mr. Belk's behalf. State's position on bail.
State is recommending a signature bond with the condition that he not operate a motor vehicle. I'll note this defendant continues to, in support of that condition, he continues to drive and pick up IID and OAR charges. He has bail conditions out of Sauk County to not operate a motor vehicle without a valid driver's license, but it's the state's position that that should be a blanket, no operation in regards to this case.
No objection.
I will order a signature bond. I will order that you not operate a motor vehicle during the pendency of this case.
What if I'm good to get my breathalyzer, I just got no set of it.
If you obtain a valid license or any of that with those exceptions, you can always petition the court to modify those bails. But at this point, given another case that is pending, the charges as alleged, I'm gonna order that you not operate a motor vehicle during the pendency of this case.
Now, I'm not gonna get in trouble if I get my privileges back, I just can't operate, right?
You can give the court would need to change that current order. So as a criminal offense, you
You
cannot
can
operate a
get it,
motor
you can get your license. If you get your license back, that's fine, but you cannot operate a vehicle.
Oh, sweet. All right, yeah, that makes perfect sense. Thank you.
Good luck, sir.
Good luck, sir.
Next will be AILANI Martinez-CASTRO via Zoom.
So you're reading.
6 West Station in York. Oh.
Court will call 25 CM 3037, State of Wisconsin versus AILANI Martinez-CASTRO appearances.
Sam Smith for the state.
Eric Schlitter appears with AILANI Martinez-CASTRO, who appears by Zoom from the Dane County Jail. Ms. Martinez-CASTRO, can you give me a thumbs up through the little window there if you can hear me all right? Okay, I'm seeing a thumbs up from Ms. Martinez-CASTRO. Is the 5340 Magdalene Court address still the best mailing address for you?
Yeah.
Okay. Ms. Martinez-Castro did indicate that's correct. Judge would acknowledge receipt of the criminal complaint. Wait for more reading. Ms. Martinez-Castro is eligible for public defender representation.
I have reviewed the criminal complaint. I do make a probable cause finding. I will enter a not guilty plea on AILANI Martinez-Castro's behalf. I believe the state said that there is someone who alleges to be a victim in this case who wishes to make a statement. Is that correct?
Yes.
If you are here on the Martinez-Castro case, please unmute yourself. Please state your name and spell it for the court reporter.
My name is Tamara Magonis, Tamra Magonis, Migonis.
And are you a victim in the Martinez-Castro case and you wish to make a statement to the court?
I do wish to make a statement, Your Honor.
This is your opportunity to tell me what you think I should do in regards to bail. Go ahead, ma'am.
I do believe that she should be able to return to our home, her home. I do believe that she should be able to have contact with myself and the members of our family. I think that no alcohol or alcohol treatment is appropriate. Also, mental health counseling. And I feel that a signature bond would be appropriate as well.
Thank you, ma'am. The court will take your statements under consideration when setting bail. State's position on bail.
State's recommending a signature bond and a condition that the defendant not consume or possess alcohol.
Any objection, counselor?
No.
I will then order a signature bond. I will order as conditions that you are not to consume or possess any alcohol during the pendency of this action. We are adjourned on Ms. Martinez-Castro's case.
Next will be Kevin Allen. Allen. Come on, here it is. Come on, the last place.
Court will call 25 CM 3033 State of Wisconsin versus Kevin Allen. Appearances.
Sam Smith for the state.
Eric Schlitter appears with Kevin Allen, who appears in person in custody. Mr. Allen, I believe, is not currently eligible for public defender representation. Would acknowledge receipt of the criminal complaints, wait for more reading. Believe the address listed is correct.
Mr. Allen, they've given you a copy of the application for the public defender's office. I think at this point you're over income. You can take a look at that. You can appeal that decision. You can hire your own counsel, but you do have a right to an attorney in this matter. You just got to pursue different avenues at this point. You might become eligible too, so you can always reapply. So that form tells you that information. I have reviewed the criminal complaint. I do make a probable cause finding to these misdemeanor charges. I will enter a not guilty plea on Mr. Allen's behalf. State's position on bail.
I believe there's a victim in this matter that wants to be heard.
If you're here on the Allen matter, please unmute yourself. Please state and spell your name for the court reporter.
Nicole Allen, and it's Nicole, Nicole, Allen, Allen.
Ma'am, this is your opportunity to tell the court what you think I should do in regards to setting bail here today.
Okay, well, me and Kevin have been together for 18 years and married for 13. My husband is a devoted father to his two children, who's 16 and 12. We depend on him every day. We haven't had no domestic issues in over 8 years. This incident does not reflect who my husband truly is. At the time, my husband was grieving over the loss of his cousin, who was like his brother, and he was drinking. We argued and things escalated like they never have. And Kevin was the one who actually called the police. I want the court to know that I was not hurt. I had no injuries and I did not need no medical attention. This was emotional, not a pattern of abuse. Kevin is a hardworking man and maintains his job for 5 years. I got family here from out of town. You know, we supposed to be doing, it's Christmas and my kids need their father home. You know, I know he be drinking, and I believe that this incident should not define his character.
Thank you, ma'am. The court will take it all under consideration when setting bail. State's position on bail.
State's recommending a signature bond along with the conditions that the defendant have no contact with Nicole A., no use or possession of alcohol, and no use or possession of controlled substances or drug paraphernalia without a valid prescription. Commissioner, especially after hearing the wishes of the victim, at least from the state's perspective, I'm usually extremely reluctant to go against the victim's wishes. I'll note here, starting 17 CF 579, Mr. Allen was convicted of misdemeanor battery and disorderly conduct with this same victim.
That was like
18
8 years
CM
ago.
1090.
You cannot interrupt. You had your opportunity. It's now the state's turn.
I'm sorry, I apologize.
Thank you. Go ahead, sir.
18 CM 1090. Again, misdemeanor battery against the same victim. 18 CF 1428. Misdemeanor battery. And then these charges today. So I think with Mr. Allen's criminal history and the fact that his history largely involves the same victim, it's the state's position at this time that contact is not appropriate.
Counsel.
Judge would have no objection to a signature bond, but would object to a no contact with Nicole A. I won't rehash. The court just heard what Nicole's wishes are. This is her husband. They've been married for over a decade here. The holidays are coming up and families in town. I think Nicole A is in a better situation than the state to, I think, know what she needs and what's appropriate. These are misdemeanor charges here. And as the state even noted from its own recitation, any history is, I think, fairly dated at this point, being almost, I think, 7 or 8 years old. So under all those circumstances, Judge, I think a condition of no acts or threats to violence for Nicole A would be perfectly sufficient. And I would ask the court not to impose a no contact.
The conduct in the criminal complaint is disturbing. It's clear that alcohol and potential other substances played a factor. So I will order that the defendant have not use or possess any alcohol during the pendency of this action, not use or possess any controlled substances or drug paraphernalia without a valid prescription. In regards to contact with Nicole A., she did eloquently state that she wants contact. She needs Mr. Allen. He's been hardworking. There is the prior domestic history, as she stated, was 8 years ago. Those charges give this court pause and concern regarding contact, but given the age and passage of time from those previous convictions to now, I am going to order that you direct no acts or threats of violence towards Nicole A. If you violate in any way, shape, or form, it will definitely be a no contact going forward, and it'll probably be a cash bail case going forward. But given the length and time between her history, Mr. Allen, and the requests of both parties, I will give you a signature bond. Time limits as to the preliminary hearing, counsel. Oh, never mind. They're misdemeanor charges.
Yeah, I'm sorry, but
Sorry.
never mind.
We are adjourned on Mr. Allen's case.
Thank you.
Good luck to you, sir.
Good luck.
It's the string. Okay.
Next be Ronnie Murphy. Ronnie Murphy.
Django. There we go. I'm gonna get yourself involved. Big work, please down.
Court will call 25 CM 3044. State of Wisconsin versus Ronnie Murphy, appearances.
Sam Smith for the state.
Here Senator appears as Ronnie Murphy, who appears in person in custody. Mr. Murphy is not currently eligible for public defender representation. The address listed on the criminal complaint is currently correct.
Mr. Murphy, you're being given a copy of the public defender application and the process that you can appeal that decision, or you can reapply depending on if you remain in jail or become eligible. That gives you information. This is a criminal case. You have a right to counsel. I have reviewed the criminal complaint. I do enter a not guilty plea after making a probable cause finding. I believe there is someone who wishes to make a statement in regards to this case. Is that correct?
Yes.
If you are here on the Murphy case, please unmute yourself. Please state and spell your name for the court reporter.
My name is, can you hear me?
Yes.
My name is Jemiah Brown, JamyiA Brown, Brown. I am Ronnie Murphy's wife. Ronnie is
Okay.
my husband.
This is your opportunity to tell the court what you think I should do in regards to setting bail here today.
I believe he should get a signature bond. I do not believe he should have to pay a bond. My husband has mental health issues. I really did not want him in jail. I wanted him with the crisis team. However, I guess they didn't have any room. I'm not afraid of my life. I want my husband to be with us for the holidays. I would like for him to be released. I just really want help, mental health help for him, but I cannot get that for him. He has to want the help himself. So all I'm asking for is to be lenient on him, because I didn't even think he deserved to be in jail.
Thank you, ma'am. The court will take it under advisement in regards to setting bail here today. What is the state's position on bail?
State's recommending a signature bond along with the conditions that the defendant have no contact with Jemiah B. JAMYIA, a ban from the 3000 block of Maple Valley Drive in Madison. No consumption or possession of alcohol. No consumption or possession of controlled substances or drug paraphernalia without a valid prescription. And I'll just note, if the court is not willing to order a no contact here, I would ask for pretrial services to remotely monitor the alcohol and drug use. In support of the no contact here, I would note, while there isn't a lengthy criminal history involving the same victim, I think what's alleged here is particularly concerning, specifically the defendant yelling in the children's faces about being the devil, talking about annihilating everyone in the home, and it's a clear mental health issue that's, I'm sure, there's alcohol and drugs involved. But in further support of the no contact, I would just note the 72-hour no contact was enforced. Thank you.
Counselor.
No objection to the signature bonds, and no objection to the condition not to possess or consume alcohol or any other controlled substances without, I think, a valid prescription. As far as the no contact and the geographic ban, again, we heard directly from, I think, the listed alleged victim here. She would like to have Mr. Murphy back at home. And I think, again, he is integral here to their family. The state mentioned not much criminal history for Mr. Murphy. I think by my count, all I can see is that he had a disorderly conduct forfeiture from back in 2020. I don't see any other cases. So I don't think it's necessary here at all based on, the charge alleged or Mr. Murphy's past criminal history, or lack thereof to order a full no contact, against the alleged victim's wishes. So would ask the court not to impose that condition.
I will give Mr. Murphy a signature bond. I will order that you not possess or consume any alcohol or controlled substances or drug paraphernalia without a valid prescription. I will order referral to pretrial services to monitor that condition. I will order no acts or threats of violence towards Jemiah B. or any members of her family. I will not order the no contact given Miss Jemiah B's desire and the lack of history of Mr. Murphy, and the information provided by Miss Jemiah B today. Sir, you need to make sure that you direct no acts or threats of violence towards her. It will be a no contact condition if you are to pick up any new cases going forward. We are adjourned in Mr. Murphy's case. Good luck to you, sir.
So, excuse me. I have one question, Aaron.
You want to make sure you talk to your counsel first.
The person I'm attorney for it, and they're the victim, or they're the defendant. Did I read that first one? This is it.
Yep, go ahead and read it. We're fine.
And also the other one I have is Francisco. Like that. Yeah. So the first case is gonna be over the phone. So we're executive over there. Correct.
That be Terry close. I apologize, Hakeem Bowlins is who we're gonna do this. Hakeem Bowlins.
I told that you wanted the hospital as a release.
Like just now.
Yeah.
Sorry, I said that.
Like release back,
Hospital.
release from the hospital to the back to the sheriff's department, or released gone?
I was in contact at about 2, just before 2. And they were still out there.
The sheriff's department was with him out there, right?
Yeah.
Yeah. Right, so it has to be back to the custody if he was cleared.
So. Yeah, the interpreter asked the question.
This doesn't give me any ideas as to why he's hospitalized, not that I need to know, but sometimes it comes up in the interpreting, so.
It sounds like he's been
So-
released, so we're trying to figure out where he is, so we might not be.
Alright, sound good. Alright, sound good, thanks. Alright. I'm told he's released.
From custody, correct?
Yeah.
Yeah, because he's still at the hospital.
Yeah.
So
So He's no longer in custody.
He is no longer being guarded by us, so correct, no longer in custody.
Which one is that?
Pineda?
I got it right here. Franklin Pineda Bolines, that's Bolines. 25 CP 481. Yeah.
So it was a return on warrant.
Yeah. Are you ready for the other one then?
Right, hold on, just.
Yep, I guess we'll see it on Monday, but it's.
Yeah, I'm ready to go. Give me this one back.
Yeah.
What you want to do?
Put it up.
Yeah, I'll keep it for a second.
Francisco Martinez Velentine will be our next.
Francisco Martinez Valentin. I can take it with me.
Is there a victim needing interpretation on this one from the state?
¿Alguna víctima necesita interpretación del Estado?
No?
No information that I have.
Okay.
No de la información que tengo yo.
Court will call 25 CF 2936, State of Wisconsin versus Francisco Martinez Velentine, appearances.
Sam Smith for the state.
Eric Suter appears with Francisco Martinez Velentine, who appears in person in custody. Mr. Velentine is eligible for public defender representation. Acknowledge receipt of the criminal complaint. The address listed is correct.
Court will note that interpreter Fred Svensson is interpreting for the court from English to Spanish and Spanish to English. I have reviewed the criminal complaint. It alleges one felony charge. State's position on bail.
State's recommending a signature bond. No contact with Caitlin G. That's CAITLIN. A ban from HH Accurate Arborist. And any place, or a ban from any place Caitlin G occupies. And I'll note, while there isn't anybody speaking here, that individual is in support of all the bail conditions recommended by the state.
Step with a moment, Judge. Judge, no objection to the signature bond or the no contact with Caitlin G, and not to be at the, I guess, address of the previous employer. As far as the condition not to be at any place she resides, I guess I just don't have any information about what that address might be, so I don't know if that would be clear to Mr. Martinez Velentine.
Court will order a signature bond, no contact with Caitlin G or HH Accurate Arborist. Time limits as to the preliminary hearing.
We'd ask that they be kept.
You'd ask that they what?
They remain.
Time limits shall remain and a preliminary hearing shall be timely scheduled. We are adjourned in Mr. Martinez Velentine's case.
That's it for me. Or it should be, I think, check it. Quick, but I believe that's it.
Thanks, Brad.
Thank you. I give this back to you. Merry Christmas.
It's not a big show. That's be Hakeem Bowens.
Hakeem Bowles. They stand up, yell at us.
Court will call 25 CF 2859, State of Wisconsin versus Hakeem Bowens, appearances.
Sam Smith for the state.
Eric Sluder appears with Hakeem Bowens, who appears in person in custody. Mr. Bowens is eligible for public defender representation, would acknowledge receipt of the complaint. The address listed is correct.
I have reviewed the criminal complaint. I do make a probable cause finding as to count 2. I will enter a not guilty plea on Mr. Bowen's behalf. Is there someone who wishes to make a statement on this case?
I believe so.
If you're here on the Bowens matter, please unmute yourself. State and spell your name for the court reporter.
Jasmine Alexander, JASMINE. Do you need my last name too to spell it out?
Yes, please.
Okay, ALEXANDER.
This is your opportunity to tell the court what you think I should do in regards to setting bail here today.
Okay, Hakeem and I were together for 9 years. We have 3 kids together. He is a very hardworking man with the longevity of the same job. I feel that him having such a serious charge, he would not be able to work at his employer and would not be able to provide for his kids if he was found convicted. I would ask that he has a signature bond and be allowed contact with each other due to us having 3 minor children together, one with medical conditions that needs both of our attention. I respectfully request that Hakeem's charge be reconsidered from a felony H to a misdemeanor. I believe that a more appropriate approach would be for Hakeem to participate in anger management, as this would better address the underlying issues without the severe consequences of a felony. I feel that anger got the best of Hakeem on the night that he made the threat towards me, and we all say things that we don't mean. I don't want to see him facing a felony charge and would appreciate if this would be reduced to something smaller. Thank you.
The court will take that under consideration. Today, we're just setting bail. State's position on bail.
State's recommending a signature bond along with the conditions that the defendant make no acts or threats of violence towards Jasmine A. And that he not possess any dangerous weapons.
Any objection?
No objection.
I will then order a signature bond for Mr. Bowens. I will order that you direct no acts or threats of violence towards Jasmine A during the pendency of this action. I will order that you not go armed with any dangerous weapons as that is defined by statute. Time limits as to the preliminary hearing, counsel.
Would waive time limits.
10 minutes are waived. A status conference shall be scheduled. We are adjourned on Mr. Bowen's case. Good luck to you, sir.
Thank you, John.
Next is gonna be Russell Miller. Hold that, so via Zoom, hold that may not be closed appropriately and cannot open the back slide.
Be invited to the fun.
Court will call 25 CM 3031, State of Wisconsin versus Russell Miller. Appearances.
Sam Smith for the state.
Eric Sluder appears for Russell Miller, who is currently in custody in the Dane County Jail. I believe I can see Mr. Miller by Zoom in his cell. I don't know, Mr. Miller, can you give a thumbs up through the window if you can hear me all right? Okay, it looks like Mr. Miller gave a thumbs up. Mr. Miller, is the mailing address on Easttown Boulevard so the best mailing address for you? Okay, appears to still be giving a thumbs up. Would acknowledge receipt of the criminal complaint. I do not currently have any information about Mr. Miller's eligibility for representation.
I have reviewed the criminal complaint. I do make a probable cause finding. I will enter a not guilty plea on Mr. Miller's behalf. Mr. Miller, these are criminal matters. You have a right to an attorney. You need to make sure you apply at the public defender's office, see if you qualify for an attorney at state expense. You may appeal that decision if you are rejected. You can also hire your own attorney at any point. State's position on bail.
State's recommending a signature bond, a ban from the DoubleTree Hotel, and no contact with Raymond A. It's RAYMOND. No contact with Anthony H. And no contact with Nathan B. And Nathan spelled NATHAN.
Any objection, counsel?
No objection to the signature bond, but object with conditions. This appears to be Mr. Miller's only criminal case that I can see here in Wisconsin. Given the lack of any history, I don't know that more specific conditions are necessary for Mr. Miller at this point.
I will give Mr. Miller a signature bond, given the allegations in the complaint, the violence that's alleged, and the victims. I do believe that the additional no contact requests are appropriate. I will order no contact with the DoubleTree Hotel, no contact with Raymond A, Anthony H, and Nathan B. We are adjourned in regards to Mr. Miller's case. Good luck to you, sir.
Next will be Terry Brooks. Mr. Brooks.
There we go.
Court will call 25 CF 2933, State of Wisconsin versus Terry Brooks. Appearances.
ADA Sam Smith for the state.
Eric Sitter appears with Terry Brooks, who appears in person in custody. Mr. Brooks is eligible for public defender representation, would acknowledge receipt of the criminal complaint. Would ask the court to update Mr. Brooks' mailing address to the Dane County Jail.
I have reviewed the criminal complaint. It alleges 2 felony charges. State's position on bail.
State's recommending cash bail in the amount of $3,000, along with the condition that he not use or possess controlled substances or drug paraphernalia without a valid prescription. Reason for the cash, looks like the defendant had an opportunity for jail diversion during his last sentence, but wasted that opportunity by cutting off his GPS bracelet and escaping from custody. It's that reason, or for that reason, the state feels that some cash is necessary to ensure his appearance in court.
Judge would ask the court to order $500 cash bail here for Mr. Brooks. I understand that this is, at this point, certainly not a signature bond case, given the allegations against Mr. Brooks. I would note that he is indigent and eligible for public defender representation. I think part of the bond, calculus is what is appropriate given somebody's means. And given Mr. Brooks' limited financial ability, I would ask the court to impose a $500 cash bail.
Given the opportunity that was given to the defendant and the allegations that he went AWOL from the jail and then cut the jail diversion bracelet off, I do believe cash bail is necessary. I will set cash bail in the amount of $2,500. I will also order that you not possess or consume any controlled substances or drug paraphernalia without a valid prescription during the pendency of this action. Time limits as to the preliminary hearing, counsel.
Leave the time limits, please.
The preliminary hearing shall be scheduled timely. We are adjourned in Mr. Brooks' case. Good luck to you, sir.
Next will be D'Angelo Hood, it's a bail hearing.
Angela Hood.
Court will call 24 CF 428 State of Wisconsin versus D'Angelo Hood appearances.
Sam Smith for the state.
Eric Schluter appears with D'Angelo Hood, who appears in person in custody. Mr. Hood is eligible for public defender representation. We're updating Mr. Hood's address to 2206 University Ave, apartment 205, Madison, Wisconsin, 53726.
State want to give its position on bail or let defense go first?
I would prefer to let the defense go first.
Counsel.
Thank you, Judge. So I know that we're back here for Mr. Hood on the return on warrant from a missed appearance. It's my understanding that around the time of the missed appearance here, Mr. Hood had been, I think, dealing with COVID. Obviously, there was a bit of time there where Mr. Hood, I think after that fact, was not necessarily in court. It's my understanding that Mr. Hood, given his indigency, does not have the ability to post any sort of cash bail. So under the circumstances, I guess I would ask to see what the state's requesting and certainly be happy to respond to that.
State's request on bail.
State's requesting cash bail in the amount of $2,000, along with the reinstatement of the non-monetary conditions. I believe there are no contact with Andre T, banned from the 300 block of Island Drive, no weapons and no alcohol. Reason for the cash request, I believe the failure to appear was June 24th, 2024. Looks like a bench warrant was issued. Defense indicated that he may have had COVID and indicated he was not necessarily in court. I agree with that. If I'm reading this right, he was in warrant status for well over a year. I think cash is necessary.
Counselor.
Judge, we would be asking for a signature bond, just given Mr. Hood's, again, lack of any ability to post cash bail here. Certainly, it does not help Mr. Hood that he was in warrant status for that time, but I would note that he did not pick up any new criminal charges in that time, including any bail jumps. Again, while this felony case was sitting open, by my view as CCAP, Mr. Hood has a very limited criminal history. Otherwise, I think the last case that he had prior was a 2016 case. So I do think that Mr. Hood is certainly, while he did have that one issue, appearing for court does not appear to be any sort of problem out in the community or any danger to the listed victim here or anybody else at this point. This was, from what I can tell, the first missed appearance that Mr. Hood had in the case that is pending here. And I think for that missed appearance, certainly Mr. Hood has been sitting in custody now, being picked up on that warrant as punishment for it. So I do think that time in custody is certainly a reminder that he does need to come to court. In lieu of any cash, if the court felt it was necessary, we'd ask the court to put Mr. Hood on, I think GPS pretrial services monitoring. I think that would provide some additional oversight in lieu of the necessity for cash.
There was a PSA report originally done in February of 24. It says that he does have a prior failure to appear that was older than 2 years. We now have this current failure to appear where he was on warrant status for almost a year and a half. Given all of that, I do believe cash bail is necessary to assure Mr. Hood's appearance at future court dates. I will set it in the amount of $1,000 and reinstate all non-monetary conditions. We are adjourned in Mr. Hood's case.
That could be KRISTAN RAE via Zoom.
Court will call 25 CM 3035, State of Wisconsin versus KRISTAN RAE appearances.
Sam Smith for the state.
Eric Schluter appears with KRISTAN RAE, who appears by Zoom from the Dane County Jail. Ms. Dobzinski, can you give me a thumbs up through the window if you can hear me all right? Okay, Ms. Dobzinski is giving me a thumbs up. Is the 615 East Washington Avenue still the best mailing address for you, ma'am?
Oh, yeah.
Speak up so you can hear you.
Yes, it is.
Okay. Judge would acknowledge receipt of the complaint. Ms. Dobzinski, well, I do not currently have any information about Ms. Dobzinski's eligibility for representation.
I have reviewed the criminal complaint. I do make a probable cause finding as to count 3 and enter a not guilty plea on Ms. Dobzinski's behalf. Ms. Dobzinski, it's a criminal matter. You have a right to an attorney. You need to make sure you apply at the public defender's office, see if you qualify. You can appeal that decision if you are turned down. You can always hire your own attorney to represent you in this matter. State's position on bail.
State's recommending a signature bond, a ban from the 300 block of East Mifflin Street. No contact with the co-defendant, Brittany Below, and no consumption or possession of controlled substances or drug paraphernalia without a valid prescription.
Any objection?
Ms. Dobzinski, did you hear all the conditions the state was asking for along with the signature bond? Okay, do you have any objection to those that you and I need to speak about?
Well, I do not.
Okay, no objection, Judge.
I will then give Ms. Dobzinski a signature bond. I will order that you are banned from the 300 block of East Mifflin. I will order that you have no contact with Brittany Below, and I will order that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. We are adjourned in Ms. Dobzinski's case.
Next to be David McCarter. It's a bail hearing. McCarter. David McCarter.
Court will call 20 CM 1780, State of Wisconsin versus David McCarter. Appearances.
Sam Smith for the state.
Eric Schluter appears with, excuse me, David McCarter, who appears in person in custody. Would update the mailing address for Mr. McCarter, the 954 North 37th Street, number 210, Milwaukee, Wisconsin.
State's position on bail.
State's requesting cash bail in the amount of $1,500, along with the reinstatement of the non-monetary conditions. I'll note bench warrants issued June 27th, 2025, November 26th, 2024, July 11th, 2023, and April 13th, 2021. Also note, it's my understanding, I believe Mr. McCarter was in warrant status for approximately 6 months. For those reasons, the state feels cash is necessary.
Medication was everything.
Judge, we are asking the court to put in place a signature bond here. The request is primarily based on Mr. McCarter's inability to post any cash bail. I would note that it appears that Mr. McCarter, I think, appeared in court after the last warrant was quashed in March, on March 19th of 2025. It doesn't appear that he had an attorney appointed to his case on that date. In speaking with Mr. McCarter, I think shortly thereafter, around the missed appearance, towards the end of June, Mr. McCarter has been dealing with heart issues. He was in the hospital several times, had surgery. So I do think that was the reason for Mr. McCarter's missed appearance then. I think based on the medication that he's been given since then, in my conversation with Mr. Carter, it sounds like that's impacted sort of his memory and just, I think, general understanding around what's going on. It looks like an attorney has since been appointed and is currently appointed, an attorney Jacobson. So I think with that, and with Mr. McCarter now knowing, who his attorney is, I do think that he would appear in court here, given his appearance before this last miss in March. So would ask the court to impose a signature bond. I would note these are misdemeanor matters, and I think this is the plan is ultimately to hopefully have this adjudicated. So ask the court not to have Mr. McCarter sitting in custody over the holidays on cash bail.
This case has been pending since 2020. I know that there was a PSA back then, and he's got no prior criminal history noted in there. He was given a signature bond, and ultimately he has pled to the charges and was in a deferred program, it looks like. Pled back on April 18th of 2022. He's had multiple missed court appearances. He had $350 cash bail. It wasn't enough to assure his appearances. That bail was forfeited. However, given the deferred prosecution, the number of days in jail, and the charges pending, and the lack of ability to post bail, I think Mr. McCarter may be doing longer in jail sitting on cash bail than he may get on sentencing, given the lack of history in regards to his criminality. But Mr. McCarter clearly is not appearing for court dates, so I do believe some cash bail is necessary. I'm going to set it as low as I think I can. I'm going to set it in the amount of $200. I'm going to order all reinstatement of all non-monetary conditions. We are adjourned in Mr. McCarter's case. Good luck to all parties.
Next be Brittany Below. Yes. Right.
Court will call 25 CM 3034, State of Wisconsin versus Brittany Below. Appearances.
Sam Smith for the state.
Eric Sluter appears with Brittany Below, who appears by Zoom from the Dane County Jail. Ms. Below, can you give me a thumbs up through the window there if you can hear me all right? Okay, she is indicating that she can hear me. I would update the court as far as mailing address. I believe 1819 Aberg Avenue, Madison, 53704 would be the best mailing address.
Yes, sir.
Just got a bunch of.
Yes, it is.
I have reviewed the criminal complaint. I do make a probable cause finding. I will enter a not guilty plea on Ms. Below's behalf. State's position on bail.
State's recommending a signature bond, banned from the 300 block of East Mifflin Street. No contact with the co-defendant KRISTAN STOPCZYNKSI, and no consumption or possession of controlled substances or drug paraphernalia without a valid prescription.
Any objection, counsel?
Ms. Below, did you hear all the conditions the state was asking for along with the signature bond?
I did. I
Okay.
agree. Yes, I agree. I agree,
Okay,
sir.
no objection, Judge.
No
I will then
objection.
I'll give Ms. Below a signature bond. I'll order no contact with KRISTAN STOPCZYNKSI. I'll order a ban from the 300 block of East Mifflin Street. I will order that you not use or possess any controlled substances or drug paraphernalia without a valid prescription during the pendency of this action. We are adjourned in Ms. Below's case.
Thank you. Happy holidays to you. Yay.
All right, watch your fingers.
Yeah.
Nope. You need to mute yourself.
Next is gonna be Jorge Garduno. For extradition. This is an extradition hearing.
Jorge Garduno.
Is it a waiver or go?
The waiver.
Do you have the form for the extradition? Court will call 25 CF 2940, State of Wisconsin versus Jorge Garduno, appearances.
ADA Sam Smith for the state.
Eric Sutter appears with Jorge Garduno, who appears in person in custody.
We are here for an extradition initial appearance. It is my understanding that Mr. Garduno wishes to waive his right to have an extradition hearing. Is that correct, Mr. Garduno?
Yes, Your Honor.
You've had enough time to talk with Attorney Schluter and go over that right, and you wish to waive that right. Have you had any alcohol, drugs, or medications within the last 24 hours that interfere with your thinking here today? Has anyone promised you or threatened you in any way to waive your right to an extradition hearing?
No.
Do you read, write, and understand the English language? What grade of schooling have you completed?
Okay.
I will find that your waiver is knowing, intelligent, and voluntary, and I will remand you to the custody of the Sheriff's Department.
Your Honor, as of now, there's no time limit.
Nope, you'll have to wait and see when I will pick you up. Good luck to you, sir.
Right, congratulations.
You do it for a second?
Yep.
You too, have fun.
Next would be Terrence Baker, it's also an extradition. Terrence Baker.
You sound yellows.
Roll call 25 CF 2935, State of Wisconsin versus Terrence Baker, appearances.
Sam Smith for the state.
Eric Schluter appears with Terrence Baker, who appears in person in custody. Good afternoon.
Good afternoon. We're set for an initial appearance on an extradition. Is Mr. Baker requesting the initial appearance or waiving the extradition?
He is asking for the initial appearance.
All right, appearance, state's position on bail.
State's requesting cash bail in the amount of $5,000. I'm not asking for any specific conditions. Thank you.
Judge, we would ask the court to issue a $500 cash bail here. I would note that Mr. Baker has a pending case here in Dane County that he has been out in the community on $350 cash bail on. He's been appearing basically since that cash bond was posted in, excuse me, in August. He's had several appearances. He's also set to resolve that case. He is working with an attorney. They have a plea and sentence set on January 14th in the morning. So I think given Mr. Baker's, track record of appearing for court in that case on low cash bail, the fact that it's set to resolve here, I do believe that there's good reason to think Mr. Baker will appear for this matter on a lower cash bail than what the state's requesting.
Given his fugitive status as alleged from Illinois and the request for his return to Illinois, I do believe that cash bail is necessary. I will set cash bail in the amount of $5,000. Extradition hearing shall be scheduled. Good luck to you, Mr. Baker.
Excellent.
Next will be Julius.
Just need to set this
Yep.
date. All set.
Next will be Lavanya Austin. Is a bail hearing.
There's an initial appearance as well.
For a bail hearing, court will call 25 CM 288. For an initial appearance, court will call 25 CM 3026, appearances.
Sam Smith for the state.
Eric Schluter appears for Aviana Austin, who appears in person in custody. Further updates, Ms. Austin's mail address, 1819 Aberg Ave here in Madison.
Waive reading,
Yes.
counsel. I will enter a not guilty plea on the newest case after making a probable cause finding as to the misdemeanor charges. State's position on bail.
In the case we're here for a bail hearing, it's 25 CM 288. State's requesting $500 cash and the reinstatement of the non-monetary conditions. Looks like there was a bench warrant issued April 28th of 2025. And the defendant has been in warrant status since yesterday. In regards to 25 CM 3026, the state is again requesting $500 cash, along with the condition that she not use or possess alcohol. My reason for the cash is the same or very similar. She was in warrant status for what I believe to be approximately 8 months. There's also allegations that she gave officers several false names before admitting who she actually was when they brought up the fast ID. For those reasons, I think the state's requests for cash in each case is appropriate.
Judge, we asked the court to, in the matter set for a bail hearing, reinstate signature bond in that matter, order signature bond. We'd also ask the court to order signature bonds in the new matter. As far as Ms. Austin's initial case, would note it's disorderly conduct here. From my review of that case, it looks like, at least from the CCAF record, that Ms. Austin, I believe, appeared for her initial appearance, out of custody in that matter. And then I believe there was the missed appearance after that. From my review of CCAP, this looks to be that was Ms. Austin's first and only case, certainly listed here. There was that missed appearance. I would note that Ms. Austin, as indicated by her address, is homeless now. She's been dealing with housing issues. I think certainly for somebody dealing with the court system for the first time, it can be confusing on its own. I'd note that she also didn't have an attorney appointed to her to kind of help her through that process. Ms. Austin, I think, was picked up on the new case here, which again has misdemeanor charges. I think the state had mentioned that they were asking for cash in the second case because of, I think, the warrant status. I would just note that, again, this conduct was from earlier. This wasn't charged out and kind of sitting open. I can certainly understand if the court does feel that something more than a signature bond is necessary, but given Ms. Austin's limited means, I'd ask the court at this point, given that lack of any other history and given, I think, an indication possibly in the new case that it would be appropriate, I'd ask the court to order her to comply with pretrial services monitoring for alcohol monitoring. I think that will have a touch that has Ms. Austin working with pretrial services on a regular basis, coming back to the courthouse, and will keep her engaged in this matter without having to keep her in custody on cash bail. Thank you.
In 25 CM 288, given that the warrant was issued and it was a notice in hand from the initial appearance that Ms. Austin failed to appear for, I do believe that cash bail is necessary. I will set an amount of $200 and reinstate all non-monetary conditions. On the newest case, 25 CM 3026, given the prior warrant, I believe Ms. Austin is a risk to appear at future court dates. I will set it as low as I can in the amount of $150. I will order that you not use or possess any alcohol during the pendency of this action. And we are adjourned in Ms. Austin's cases. Good luck to you, ma'am.
Next to be Tierra Long. Edward, 7 yellow eggs.
Court will call 25 CF 2928 and 25 CM 3030, State of Wisconsin versus Tierra Long. Appearances.
Sam Smith for the state.
Eric Suter appears for Tierra Long, who appears in person in custody, but acknowledge receipt of the complaint. The complaints, wait for more reading. The address listed is correct. Would update it to, I think, notes the 1215 Jackson Street. It should be apartment number 104.
I have reviewed the charges and the complaints. As to the misdemeanor case charges, I do enter a not guilty plea after a probable cause finding. State's position on bail.
25 CM 3030, state's recommending a signature bond and no consumption or possession of drug paraphernalia or controlled substances without a valid prescription. Whereas the 25 CF 2928. State's recommending a signature bond and a ban from TJ Maxx in Sun Prairie.
Yes.
No objection.
I will then order in 25 CM 3030 a signature bond. You are not to use or possess any controlled substances or drug paraphernalia without a valid prescription. In 25 CF 2928, I will give you a signature and I will put bond and I will ban you from all TJ Maxx stores. In regards to the felony matter, time limits.
We'd waive the time limits, Judge.
Those are waived. The status conference shall be scheduled. We're adjourned in Ms. Long's cases. Good luck to you, ma'am.
Thank you.
Let's go back. That's about silence. I was thinking about Aaron's say that's fine. He wants to wait. Permits mine.
Oh, okay.
Arguing all that or.
Sure. If he wants to waive, Baker wants to waive his hearing now.
Okay.
Do you want to bring him back in? I know you already went through everything with him.
Yeah.
You have the form for the waiver on the application. It's changed his mind. So they can do that while you're catching up. Here, Counselor. Court will recall State of Wisconsin versus Terrence Baker, 25 CF 2935. Appearances are the same. Mr. Baker, it's my understanding, requested now to waive his right to an extradition hearing. Is that correct, Mr. Baker?
Yes, ma'am.
And you had enough time to talk with Attorney Schluter prior to this hearing, and you know what your extradition hearing consists of, and you wish to waive that right here today?
Yes.
And it tells me, I saw you sign this paperwork in front of Attorney Schluter. Attorney Schluter, did you have enough time to talk to Mr. Baker about his right to an extradition hearing?
Yes.
Mr. Baker, have you had any drugs, alcohol, and medications that interfere with your thinking here today?
No.
Have you been promised anything or threatened in any manner to waive your right to an extradition hearing?
No.
And you read, write, and understand the English language?
Yeah.
You understand that you could have had an extradition hearing, you wish to waive that hearing and be remanded to the custody of the Sheriff's Department for extradition to
The Illinois judge.
Illinois. Illinois, is that correct, sir?
Yeah.
I'll find that your waiver is knowing, intelligent, and voluntary. I will waive your right to an I will accept your waiver of your right to an extradition hearing, and I will remand you to the custody of the Sheriff's Department. Good luck to you, sir.
Yes. Put one of those call last night. It's awesome, it's small. Diana Garcias, Pedroza.
Protocol 25 CF 2931, State of Wisconsin versus Diana Garcias. Appearances.
Sam Smith for the state.
Eric Schluter appears with Diana Garces, who appears in person in custody. I do not currently have information about Ms. Garcia's eligibility for public defender representation, but asked the court to update her mailing address to the 1819 Aberg Ave, the job center.
I have reviewed the criminal complaint. It alleges 3 felony charges. State's position on bail.
State's recommending cash bail in the amount of $2,000, along with a ban from the 1900 block of Shelley Lane. SHELLEY. In support of the cash, it looks like the defendant now has 4 open felony cases. It's also alleged that she violated bail by being present in a banned area. I'll also note a failure to appear just recently on December 16th. That was in 25 CF 2940. She was arrested on the warrant while at the banned address where she wasn't supposed to be. And I think it's also noteworthy that she has, in those past cases, posted around $1,250 between those open cases. For all those reasons, the state feels $2,000 is appropriate.
So Judge, I guess, again, I don't know Ms. Garces' current status, but I do know that on her prior cases, it looks like she is represented by the Public Defender's Office. So I'm assuming that there is still limited capacity for Ms. Garces to be able to post cash bail. I don't know the circumstances of any prior cash bail posted. I note here, the felony bail jumps that are charged. There's one that's, based out of the fact that she's not supposed to be in that 1900 block of Shelley Lane. The other two basically just come from the condition that she's not supposed to commit any new offenses, which I believe the bail jump for being in that block is the predicate for. So it's not as if, outside of the fact that she was there, allegedly, she's not out here committing additional new violations or otherwise conduct otherwise outside of the geographic ban there. So in lieu of cash bail, it's my understanding from Ms. Garces that she wouldn't be able to post any additional cash in this case. I think given the nature of the allegation here and the violation, would ask the court to put her on pretrial services GPS monitoring. The concern here is her being in that 1900 block. I think GPS monitoring would provide that oversight and make sure that she is complying with that condition. So would ask the court to order that in lieu of cash bail.
Given the number of cases Ms. Garces has pending, given the bench warrant that was just issued on the 3 other cases on December 16th, I do believe cash bail is necessary to assure Ms. Garces' appearance at future court dates. I will set it as low as I can, and I believe I can to get her to appear to court, and I will set it in the amount of $600. I will order a ban from the 1900 block of Shelley Lane. Time limits as to the preliminary hearing, counsel.
We ask that they be kept.
They are not waived. A preliminary hearing shall be scheduled timely. We are adjourned in Ms. Garces' case. Good luck to you, ma'am.
Charges right, so. Right, so.
What do I have to be charged for this? I didn't do anything wrong, it was the court case.
That's be KANDI Julius.
Ms. Julius. You stand on the elements.
Court will call 25 CM 3036, State of Wisconsin versus KANDI Julius. Appearances.
Sam Smith for the state.
Eric Schluter appears with KANDI Julius, who appears in person in custody. Ms. Julius is eligible for public defender representation, would acknowledge receipt of the criminal complaint. Away from a reading, the address listed is correct.
I have reviewed the criminal complaint. I do make a probable cause finding and enter not guilty pleas on Ms. Julius's behalf. State's position on bail.
State's recommending cash bail in the amount of $500, along with the conditions that she not consume or possess alcohol, not operate a motor vehicle without a valid driver's license, not operate a motor vehicle with any alcohol in her system. And I would ask that she be referred to pretrial services for remote alcohol monitoring. Reason for the cash requests and those particular conditions as well. It looks like the defendant was out on bond in 2 cases, both of which had conditions to not possess or consume alcohol. And here what's being alleged, she's at a 0.16 driving and crashing into a tree. To summarize, she's not only violating specific conditions of bail, but endangering herself and others by doing so. For those reasons, the state feels some cash is necessary.
Attorney Schluter.
Sorry, just one quick second, Judge. Judge would just make a slight modification in the argument from the state here. I can certainly understand the request for cash, but I do think that given the circumstances, a slightly lesser amount would be appropriate. We ask the court to consider $250 cash here. I'm just trying to check. I don't believe cash bail has been ordered in her other cases, so I think this would be the first cash bail. I would note that it does appear that Ms. Julius has been appearing out of custody on signature bonds in the matters that the state referenced that are pending here. It does look like she's set for a plea and sentence come February. So she is working with attorney, working her way through those cases, and they are heading towards resolution. I think $250 would be appropriate, again, given the fact that I don't think there's a concern that she's not going to show up for court here, but does put some additional, I think, incentive in it for certainly Ms. Julius to abide by the conditions here. I think that with the other conditions that were requested would be sufficient.
Given the number of cases, given the potential penalty increasing, I do believe that it's becoming suspect whether Ms. Julius will appear for future court dates. Therefore, I do believe cash bail is necessary. I'll set it in the amount of $250. I will order that you not use or possess any alcohol during the pendency of this action, that you not operate a motor vehicle without a valid driver's license, that you not operate a motor vehicle after any consumption of any alcohol in your system. And I will order a referral to pretrial services for you to be monitored through for breath alcohol monitoring or whatever they deem as appropriate alcohol monitoring. We are adjourned in Miss Julius's cases. Good luck, ma'am.
Next is Shania Hope. Ms. Hope.
Give me just a minute.
Stand up, no acts.
Court will call 25 CF 2927, State of Wisconsin versus Shania Howe. Appearances.
Sam Smith for the state.
Eric Suter appears with Shania Ho, who appears in person in custody. So is eligible for public defender representation, would acknowledge receipts of the criminal complaint, would just update the mailing address on that to 1819 Abrook Ave, the job center here in Madison.
I have reviewed the criminal complaint. I do make a probable cause finding as to the misdemeanor charges and enter a not guilty plea on Ms. Howe's behalf. State's position on bail.
State's requesting cash bail in the amount of $500, along with a ban from all Woodman stores. Reason for the cash request, it looks like this is the defendant's fifth pending case. And I'll also note a failure to appear on November 7th of 2025. For those reasons, the state feels some cash is necessary.
Attorney Schluter.
Judge, we would ask the court to, I think, consider a signature bond here. I think certainly she's dealing with some felony bail jump charges, but the underlying conduct here is from back at the very beginning of December. And it's in reference to, I think, approximately $230 something worth of frozen meat that's taken from the Woodmans. I would note that Ms. Ho is, as indicated by the updated address, homeless, and has just been dealing with, I think, some significant difficulties lately. In speaking with her, she has been able to share that, I think, in the last, while these cases have been pending, she has been in contact with Journey, is on a wait list for treatment services. I do know that certainly the state's concern and potentially the courts, I'm sure, comes from the fact that there are several cases open for Ms. Ho at this point, but I believe by my review, I think this is the only history that Ms. Ho has. I don't believe that there's prior criminal convictions. So given her efforts here, I would ask the court to, I think, consider a signature bond here. She has no objection to the no contact, or excuse me, the geographic ban from the Woodmans.
This is Ms. Howe's fifth open case. Given that the penalties keep increasing, she becomes more of a flight risk with each of those. I do believe cash bail is necessary to assure her appearance at future court dates. I will set it in the amount of $400. I will order that you are banned from all Woodmans. Time limits as to the preliminary hearing.
We ask that you keep them.
Those will remain, and a preliminary hearing shall be scheduled timely. We're adjourned.
Right this way, right now.
Right, this place.
Is that last one? That. Next is Peter Hamilton.
Court will call 25 CF 2926, State of Wisconsin versus Peter Hamilton. Appearances.
Sam Smith for the state.
Eric Schluter appears with Peter Hamilton, who appears in person in custody. I'm not currently aware of Mr. Hamilton's eligibility for public defender representation, but acknowledge receipts of the criminal complaint. Would just ask that Mr. Hamilton's mailing address currently be updated to the Dane County Jail.
Mr. Hamilton's been given a copy of the public defender form, which tells him how to apply for a public defender or appeal that decision if he is not qualified, or hire his own counsel. State's position on bail.
State's requesting cash bail in the amount of $1,000, along with the conditions that he have no contact with the individual with the initials VG. It's V as in Victor and G as in Gary, and a ban from the chapter at Madison Student Housing.
Judge, my understanding that Mr. Hamilton doesn't have an objection.
I will then set cash bail in the amount of $1,000. I will order no contact with VG and a ban from the chapter Madison Student Housing. Time limits as to the preliminary hearing, counsel.
We'd ask the time limits be kept.
Time limits are not waived. A preliminary hearing shall be timely scheduled. We are adjourned in Mr. Hamilton's case. Good luck to you, sir.
I apologize. What was the signature bond or amount set in that case?
It was $1,000.
It was $1,000. Cash bonds.
Thank you.
Next would be Marcus Taylor.
Marcus Taylor, paperwork.
Roll call 25 CM 3038, State of Wisconsin versus Marcus Taylor, appearances.
Sam Smith for the state.
Eric Schluter appears with Marcus Taylor, who appears in person in custody. Mr. Taylor is eligible for public defender representation. I would acknowledge receipt of the criminal complaint. I would ask the court to update the mailing address to 1819 Aberg Avenue, the job center here in Madison.
I have reviewed the criminal complaint. I do make a probable cause finding and enter a not guilty plea on Mr. Taylor's behalf. State's position on bail.
State's requesting cash bail in the amount of $1,000, along with the condition that he not consume or possess alcohol. In regards to the cash, I'll note defendant has cut off in the past his DOC GPS bracelet. It's also alleged that he resisted arrest here. For that reason, the state feels cash is necessary.
Attorney Schluter.
Just one moment, please. Judge would ask the court to consider a lesser amount of cash bail here. But note these are misdemeanor charges here. I think Mr. Taylor has, I think my understanding, one other open case here. He did show up out of custody in that matter on November 20th. So I do think there's some recent indication that Mr. Taylor will show up to resolve these matters. I don't think they're serious enough to require a significant amount of cash bail. Would ask the court to consider a $250 cash bail for Mr. Taylor if you feel that cash is necessary.
Given the cutting off of the bracelet that's alleged, Mr. Taylor's alleged continued violations of bail as set, I do believe some cash bail is necessary to assure his appearance. I will set it at $200. I will order that you not use or possess any alcohol during the pendency of this action. We are adjourned in Mr. Taylor's case. Good luck to you, sir.
Next would be Ludale Jordan. We ready for that? All right. Oh. She got it back. Mr. Jordan.
Roll call 25 CF 2944, State of Wisconsin versus Ludale Jordan, appearances.
Sam Smith for the state.
Eric Schluter appears with Dale Jordan, who appears in person in custody. Mr. Jordan is eligible for public defender representation. The address listed on the complaint is correct. I guess I would just note it lists apartment D. I think it's suite D by my understanding, and I just don't know if that would cause any issue. But otherwise, the job center is correct.
I have reviewed the criminal complaint. It does allege one felony charge. State's position on bail.
State's recommending cash bail in the amount of $5,000, along with the conditions that the defendant have no contact with the person with the initials YAR, a ban from the 2400 block of Chalet Gardens in Fitchburg, a ban from MATC, no contact with YAR's immediate family. And I would ask that he be referred to pretrial services for GPS monitoring. In support of the cash, I'll note, we are in Act 3 territory. This is an Act 3 eligible offense in which the victim is legally blind and the defendant hasn't been staying away from the victim as well as where she resides. I'll note the defendant also has an extensive history out of the state of Illinois, which includes a range of different types of crimes, some to include burglaries, domestic violence, and a variety of felony cases. For all those reasons, the state feels $5,000 is appropriate.
Attorney Schluter.
Thank you, Judge. We'd ask the court to consider, excuse me, a signature bond here for Mr. Jordan. I think reasons being, certainly understand the severity of the charge here. I think it's significant that, based on what's in the criminal complaint, Mr. Jordan has not, I think based on the allegations, had contact, or been, I think, near, the alleged victim, since I think the last date that's listed is November 24th, when he's alleged to have been at, the victim's, apartment building. I think, by my understanding, an injunction was issued on December 1st. And so by all accounts here, Mr. Jordan has been complying with that injunction. I think that a signature bond with the pretrial services conditions and monitoring is sufficient to ensure that Mr. Jordan complies by, I think, the requested conditions that the state had noted, without needing to have Mr. Jordan remain in custody, in this matter. He is indigent and eligible for public defender representation. It's my understanding he does not have the cash bail to post in this matter. So I think a signature bond with that monitoring would be appropriate.
There's a PSA report that gives him 5 out of 6 on new criminal activity, 5 out of 6 on failure to appear, and ultimately recommends cash bail. It indicates that he has 2 or more failure to appears in the past 2 years, prior sentences to incarceration, prior felony convictions, and the charge itself is a felony matter. Given all of that and the recommendation of the PSA recommending cash bail, I do believe some cash bail is necessary to assure Mr. Jordan's appearance at future court dates. I also believe that this is Act 3 territory, therefore protection of the victim is also relevant to this court's determination on cash bail. I will set cash bail in the amount of $1,000. I will order no contact with YAR or her family. I will order a ban from the 2400 block of Chalet Gardens in Fitchburg and a ban from MATC. Time limits as to the preliminary hearing counsel.
We keep the time on this, Judge.
Time limits are not waived and a preliminary hearing shall be scheduled timely. We are adjourned in Mr. Jordan's case.
Next be Matthew Beckering.
Becker. He's sounding yours.
Court will call 25 CF 2925 State of Wisconsin versus Matthew Beckering. Appearances.
ADA Sam Smith for the state.
Eric Schlitter appears as Matthew Beckering, who appears in person in custody. I'm not currently aware of Mr. Beckering's eligibility for public defender representation. Would acknowledge receipts of the criminal complaint. The address listed is correct.
I have reviewed the criminal complaint. I do make a probable cause finding as to the misdemeanor charge and enter a not guilty plea on Mr. Beckering's behalf. State's position on bail.
State's requesting cash bail in the amount of $1,000, along with the conditions that the defendant not operate a motor vehicle, that he not consume or possess alcohol. That is all the conditions I'm requesting. In support of the cash, I'll note his last OWI wasn't, it was in 2014. He's now facing mandatory prison time, and it looks like there was an attempt to flee the scene of the crash in this case. For those reasons, the state feels cash is appropriate.
Counselor?
Just my understanding that Mr. Becker doesn't have happy to provide additional argument if the court's inclined to go over the request.
I will set cash bail in the amount of $1,000. I will order that you not operate a motor vehicle during the pendency of this action and that you not possess or consume any alcohol.
Yes, Your Honor.
Time limits as to the preliminary hearing.
Would waive time.
Time limits are waived. A status conference shall be scheduled. Good luck to you, Mr. Beckering.
Thank you, Your Honor.
Next is Theodore Bauer.
Mr. Bauer, here's your paperwork. You stand on the yellow lights.
Court will call 25 CF 2937, State of Wisconsin versus Theodore Bauer. Appearances.
Sam Smith for the state.
Eric Schluter appears with Theodore Bauer, who appears in person in custody. Mr. Bauer, I do not currently have information about Mr. Bauer's eligibility for public defender representation. Would acknowledge receipts of the criminal complaint. Would update the mailing address to East 12095 Gruber's Grove. That's GRUBER''S and Prairie du Sac. Zip is 53578.
I have reviewed the criminal complaint. I do make a probable cause finding as to count 2 and enter a not guilty plea on his behalf. State's position on bail.
State's recommending cash bail in the amount of $1,000, along with the conditions that he not operate a motor vehicle and not consume or possess alcohol. Reason for the cash, looks like he's facing a mandatory prison sentence. I don't see a lengthy history of failing to appear, but I think with that amount of exposure, at least some cash is necessary.
Judge, we would be asking for a signature bond in this matter. I think Mr. Bauer's last OWI conviction is from it's the 2011 case. His only other criminal case since then, I believe, is an OAR from 2012. So Mr. Bauer has over a decade here where he's not had any sort of criminal contact. The state mentioned no, I think, record or indication that he would otherwise present a concern about appearance. So I don't think, given that the dated history here, that Mr. Bauer is otherwise a threat. So I'd ask the court to give him the opportunity to certainly show that he can show up and resolve this case, which appears to be consistent with his record in the past. I would note that he's lived in the area and has been working for that time.
Same, I guess that works for those years. Years.
So there's an extensive history here, Judge. I don't think he's a concern to leave or not show up for court. I understand that Mr. Bauer also has custody of his 2 grandchildren. He obtained that 2 months ago, so I think there's certainly additional incentive for him to be out of custody and incentive for him to resolve this out of custody because certainly he could be picked up on a warrant and put in jail on additional cash bail if he were not to show up. So I'd ask the court to give him or consider a signature bond here.
Given the length of time between convictions for Mr. Bauer, it looks like he got his first in 98, 99, 2004, and the most recent in 2011. There's a large passage of years in between there with little to no other criminal history is brought to this court's attention. I am going to give Mr. Bauer a signature bond. I'm going to order that you not use or possess any alcohol during the pendency of this action. I'll order that you not drive without a valid license. Time limits as to the preliminary hearing, counsel.
Would waive the time, that's Judge.
Time limits are waived. A status conference shall be scheduled. We are adjourned in Mr. Bauer's case. Good luck to you, sir.
Next is Alex Dorr. Mr. Dorr.
Please stand for the evidence.
Roll call 25 CF 2938, State of Wisconsin versus Alex Dorr. Appearances.
Sam Smith for the state.
Eric Slater appears with Alex Dorr, who appears in person in custody. Mr. Dorr is eligible for public defender representation. Would acknowledge receipt of the criminal complaint. The address listed is correct.
I have reviewed the criminal complaint. I do make a probable cause finding as to the misdemeanor and enter a not guilty plea on Mr. Dorner's behalf. State's position on bail.
State's recommending a signature bond, along with the condition that he not consume or possess controlled substances or drug paraphernalia without a valid prescription, and that he be banned from all Kohl's stores.
No objection.
We'll then give Mr. Dorr a signature bond. I will order that you not use or possess any controlled substances or drug paraphernalia without a valid prescription, and that you are banned from all Kohl's stores during the pendency of this action. Won't get another signature bond if you keep picking up new cases, so make sure you comply with these rules.
Thank you.
Time limits as to the preliminary hearing, counsel.
Would waive time limits.
Time limits are waived. A status conference shall be scheduled. Good luck to you, Mr. Dorr.
Thank you. Right there.
Christopher Bullins.
Please stand for the evidence.
Court will call 25 CF 2930, State of Wisconsin versus Christopher Bullins. Appearances.
ADA Sam Smith for the state.
Eric Slater appears with Christopher Bullins, who appears in person in custody. Mr. Bullins is eligible for public defender representation. I would acknowledge receipt of the criminal complaint. Would update Mr. Bullins' mailing address to 615 East Washington Avenue, Madison, Wisconsin, 53703.
I have reviewed the criminal complaint. I do make a probable cause finding as to counts 5 and 6 and enter a not guilty plea on Mr. Bullins' behalf. State's position on bail.
State's requesting cash bail in the amount of $100,000, along with the conditions that the defendant is not be ordered to not leave Dane County, to not use or possess any dangerous weapons, and to have no contact with Whitney S. It's WHITNEY. And I would ask that he be referred to pretrial services with GPS monitoring if he posts. Thank you. Oh, I apologize. In regards to the large cash amount requested by the state, I'll note this was what's being alleged in the complaint is an extremely concerning and violent case with several Act 3 crimes. I'll also note the defendant has a warrant out of the state of Arkansas. He also allegedly tells the victim that he just got out of prison and doesn't care if he goes back. And he has zero ties to this community that the state is aware of. For all those reasons, the state feels a high cash bail is appropriate.
Attorney Schluter.
Thank you, Judge. We ask the court to consider a lower amount of cash bail here. Certainly, I can understand based on the allegations, the state's request here, but I think $100,000 is certainly more than is necessary, and certainly more than Mr. Bullins could, I think, reasonably post. part of the bail statute is to consider the means of the defendant. He is eligible for public defender representation. He is indigent, so I think $100,000 is certainly well outside of his potential means. I do believe that he's on a hold here, so I think he'll certainly remain in custody pending that holds regardless. However, I would ask the court to consider $10,000 cash bail here. I think going through the complaint, certainly there may be issues that are further ironed out at any sort of preliminary hearing, but I think going through, I think there's some there's limited information that I think necessarily points to Mr. Bullins. And so I think there certainly are potential defenses here that Mr. Bullins may have available to him. I think that is a consideration for cash bail. So for all those reasons, we ask the court to impose a $10,000 cash bail.
The crimes alleged can carry extremely high penalties. You've got a number of felony C offenses, armed robbery, kidnapping, you got second degree recklessly endangering safety. The conduct alleged is scary, as set forth in the criminal complaint. You've got someone who has an Arkansas warrant for things that include battery, first degree, robbery, multiple counts. Given all of that, I do believe, and these are Act 3 eligible offenses, given the potential penalty, given the protection of the public, I believe cash and higher cash bail is necessary for those to accomplish those goals. I will set cash bail in the amount of $40,000. I will order that you are not to leave Dane County. I will order that you are not to possess any dangerous weapons as that is described by statute. I will order that you will have no contact with Whitney S. I will order pretrial services with GPS monitoring, and I will order that that be facilitated prior to release if you are able to post bail. Time limits as to the preliminary hearing counsel.
I would ask the time limits be kept.
Those are kept. A preliminary hearing shall be scheduled timely. We are adjourned in Mr. Bullins' case. Good luck to you, sir. Thank you, everybody. We are adjourned.
Yeah, oh, you're.
Have a good holiday, everybody.
You too.